What's up, everybody? Welcome back into another episode of The Lawyer You Know. We are in full-blown vacation mode for the next couple days, so the schedule might not be exactly what you're used to, but so many of you have sent me a couple of these Lori Vallow hearings coming up to her last trial, hopefully, in Arizona, where Brandon Boudreaux is the victim. She has gotten a new judge to consider whether or not Judge Beresky should be thrown off the case, and an explosive hearing with Judge Beresky himself. I almost think that she feels like she can use arguing and going back and forth and yelling at Judge Beresky as a reason to recuse him from the case. Will it work? It's very interesting. Once you get a second judge to take a look, much better odds than having the judge that you're trying to remove look at it and make the decision, which Beresky's already denied. Will she actually win? Hit that like button. Make sure you're subscribed. Let's watch this together now. So you may notice in this video a new female judge. You'll notice the same prosecutor and the same Lori Vallow in their different squares. Let's take a listen to exactly why. We already know some of the reasons she wants Judge Beresky off the case, but she's going to get to argue them. We're going to see the fire and passion in Lori Vallow's eyes and voice and expressions here at this hearing, which could lead us to think, will there be more fireworks between she and the judge in this very last trial potentially for Lori Vallow, unless there's more things popping up I don't know about? Let's take a listen.
Good morning, everyone. The court calls CR 2022-00124201. This is State versus Lori Daybell. Appearances, please.
Attorney Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense.
And Pamela Hicks, Advisory Council.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request?
So as we know throughout the entirety of basically Lori Vallow's, I don't know what to call it, 10-year saga case, multiple cases, whatever we want to call this, road of destruction that she's left behind her, she has not wanted the media to be involved. She has not wanted the cameras. She got the cameras removed from her first Idaho trial, I should say. It was here in the first Arizona trial, and she is going to object again. She does not want the media to make a spectacle of this, but because we live in America, and hashtag shout out America with my shirt, we have public access because when there is public interest, the public has a right to be there and see how these trials go and see what justice looks like in our system.
From the state?
No, Your Honor.
Okay. From the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay. I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
Always. I always object to them. Oh, you object? Always.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Beresky for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish.
So there are some maybe new things, the religious bias, the facial expressions. We know she was going to say he denied every one of her motions and arguments. She always loses, basically, so therefore it's biased. We know that that is not enough to get a judge removed. But facial expressions, is he showing that he's biased against her? Religious discrimination, what does she have there? Let's see what type of arguments she makes, because we got a new judge looking at this with fresh eyes. Now, we know from the YSL trial and some other trials where they try to remove judges, it doesn't usually go well. But when it gets to this level, it becomes a possibility. Not likely, but a possibility.
Judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Beresky can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware.
The question is not, does he like Lori Vallow? The question is not, does she win or lose any individual argument or multiple arguments? The question is not, is she guilty or not guilty? The question is not, did she lose or win the last trial? The question is, can he be fair and impartial? Has he acted in a way that has made this court, now looking at it, say no? He has proven that he cannot be fair and impartial. We've had tons of these happen in our cases. It's very rare that they get granted. We've followed some cases where this has happened. And again, it's very rare it gets granted, but it is possible. If the actions are blatant enough, if they're material enough, if they're obvious enough, another judge doesn't want that. They don't want the trial court judge to be a reason for an appeal. They don't want a trial court judge doing this over and over again and then creating issues potentially in other cases. Is he going to have to be recused and removed? Is this something that we need to nip in the bud? Is he acting horribly unfair and biased against Lori Vallow? Now, it's pretty clear no, if you ask me, but how will this judge see it?
For the allegations, you'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in this.
I'm sorry, can you pull the microphone? I'm sorry, I can hear you.
Sorry. I did file this motion in this affidavit after several attempts to, I made an oral motion with Judge Beresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from the state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And
so is that the religious discrimination? Because very clearly it's not. Maybe judges shouldn't make extrajudicial comments like that. I don't think personally that was that big of a deal. Would it have been better if he didn't say that? Yes, I actually think she's right. He shouldn't have said that. Nowhere near rising to the level of what she's trying to say it does in this case. Number one. Number two, another interesting thing I heard her say that was fascinating is she didn't even notice it. Somebody else pointed it out to her. So who's helping her? Is that standby counsel? Is that a lawyer? Is that her paralegal? Is that her investigator? Or is it somebody from the public? Is it a supporter, an admirer, a family member? Who is helping Lori Vallow at this juncture?
so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my Sixth Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge.
She's right. That's exactly the question here. Is this judge creating an atmosphere and environment that violates her right to a fair trial by being biased against her, by being unfair? That is the question. She understands the question, but she thinks what she's arguing rises to that level, and it just legally doesn't.
Who has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Beresky applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or
So we get into, again, something I talk about all the time, especially when I'm talking to groups and doing presentations, like the way judges are now limiting cameras and how they're learning from each other. And, one Idaho court learning from another Idaho court. And from my perspective, I think that's great. And I think that helps. We're building the precedent right now for cameras. You can have cameras in the courtroom. It's necessary for public access, but don't focus in on the defendant's face or papers or have high sensitivity microphones that is going to pick up privileged conversations. We're learning. Right? We don't want to over sensationalize it, but we want to give the public the access that they need and deserve as a society today that says we have an open public court system. This affects us, our loved ones, our lives, and we're learning how to develop that. And that's what I think is really cool because we know what cases they're talking about, right? Talking about her case in Idaho, Daybell's case, the difference is there. The judge allowing cameras in one and not in the other. What are defendants asking for? What are the cameras going to do? We see the Koberger court, one camera. How they're limiting that. At least that's how judge was doing it. We see the YNW, I think, Melly case that they talked about not having these high sensitivity microphones. We're building how this is going to work in our justice system in America as we speak.
things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions set the state as one have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Beresky from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Beresky is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Beresky.
And again, that may be a very valid argument. There could be discovery violation, but that's not what this court's going to rule on. That doesn't have to do with the judicial bias. Now, if the court were to find this isn't also an appeal of his prior decisions. She's not going to go back and look and legally say, would I disagree with this decision? What standard am I going to apply? Did he abuse his discretion? Was it material? She's not going to do that, right? She's not going to do that as far as trying to determine his impartiality, his fairness, and his unbiased nature of his decisions. It's not how this process works. This is not the right spot for that.
Beresky for these items for a year and a half, and I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And
so obviously the trial's already delayed. It's not going to start Monday with testimony, at least. Maybe they'll start picking a jury Monday. I don't know.
Those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it.
And that's fine, but again, that doesn't go to Beresky's being biased or unfair. And again, he is kind of, his hands are tied by what the jail says, what law enforcement says about what protection is needed. He is bound. He can't really go further, or else it's on him if something bad happens. He doesn't want to open that up. He's taking their recommendations.
And that is what MCSO recommended, that if that was too burdensome that they would put an armed guard in the back. And because of the media that Judge Beresky has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me. And all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Beresky a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Beresky, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything.
Again, but like, I'm repeating myself now, but this judge is not going to make that call right now. She's not going to make that call. We know even in the YSL case, when they removed Judge Glanville, it wasn't because of his bias and unfair nature. It's because he handled that whole ex parte hearing and how he dealt with the lawyers afterwards. That's the problem. And what he said and the statements he made around that, it wasn't even as rough as he was on some of those criminal defense attorneys and defendants. Even he did not rise to the level, according to the court that did end up removing him. That's just how wild this is. This is nowhere near. Beresky has dealt with this pretty great, in my opinion. There are some maybe things he shouldn't have said, comments, but like overall, I think he's been more than fair. So this just ain't happening. It ain't happening in any world.
Thing is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Beresky, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Beresky's substantive legal rulings,
which, by the way, like 90% of defendants do, and even defense lawyers sometimes disagree with the judge rulings. That's definitely not the standard to get him removed. I'm sure people are going to have a heyday with her saying, I'd like a new judge who doesn't know anything about the case. It's like, well, it's not really how it works, because judges always find out about the case because they need to know about the case to make the decisions on all the pretrial motions and arguments that happen.
is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated. I don't find on this record that it has been demonstrated. I certainly.
Very simple, frankly, for this judge. She already had her mind made up as my guess. She didn't wait for Lori Vallow's, astute legal argument. She read the motion. It was in writing. She let them make a record with their arguments, but this was a very easy decision by the judge.
I understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel. But the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have. If you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal.
But what you don't do, and what the recourse is not, is the motion to remove Judge Beresky. That's not one of the remedies that she said could happen by disagreeing with some of his decisions. It doesn't mean he's biased.
You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial.
It seems like even the comment from the judge, that comment alone, meaning not a great comment, probably don't say that, and that's fine, but it's a long trial, lots of stuff happening, people talking a lot, pro se defendants is difficult for judges. Maybe he shouldn't have said that comment, but come on, that comment alone absolutely does not rise to the level.
I'm not exactly sure of the context where he made it, but
That's her saying, I'm not just going to take your word for it.
sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Beresky under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
Nope. Anything else from Ms. Daybell? Nope. So another loss, but hopefully that means this trial is starting relatively soon. Maybe a slight delay because of, these motions. So now that we know she's lost and that Judge Beresky is going to be presiding over her second trial in Arizona, let's take a look at this hearing where it gets a little explosive even by the titles from people that were in the courtroom and heard the exchange between Judge Beresky and Lori Vallow. It's a clip from a hearing. I think it's like a 20-minute clip we're going to watch together where she's arguing about whether or not an aggravating factor should go to a grand jury or not. Was this process handled appropriately? Were things changed at the last minute? And if they were, that's totally unfair. And I'd be saying if the state is bringing up something new the last minute, that's totally unfair. I think there are aspects of what Lori Vallow argues here, like what is the point? What is this actually going to change about the case? Why do we need this? But that's different than is it legally proper or legally appropriate for the state to be able to do it? And Judge Beresky, well, I wouldn't say he has the patience of Job, right? Which is an analogy I've used in the past. I think he's acting completely appropriate with her. I think anybody would be frustrated with her. It's kind of different than maybe Judge Doro, who we saw with Daryl Brooks. Definitely a different demeanor there, but I think he's trying to move this case along, and he knows if he gives Lori her 15 minutes of fame, she's going to turn it into 15 hours of fame. So he is handling it appropriately, but you can feel and hear the difficulty in his voice. And you guys let me know in the chat, do you think Lori Vallow deserves the grace and kindness and patience that she believes she deserves? Because I think you can tell when he says certain things, it kind of ticks her off and she's like, no, you're not going to treat me like that. I deserve better than that, and I will be treated better than that. So let's take a listen to how she argues this motion. It's very obvious that she just clearly gets things legally wrong multiple times. And sometimes it's even hard for me while we're breaking this down to figure out where she's going with an argument. Cause it's like, oh, I would make this argument. It's like, no, she's not making that argument. She doesn't understand the full background and legal context, probably because she's not a lawyer. But let's take a listen to this hearing.
Aggravation phase, from my understanding that we did over my objection last time.
Well, we actually didn't do an aggravation phase.
I
admitted-
stipulated to it.
You stipulated to it.
Correct. But in adding it to, at the end of trial, a whole guilt phase for aggravators, my understanding is that in January, the state filed their motion, the state's allegation of aggravating circumstances, right? And then my understanding is that that can be brought to the jury during guilt phase. And so, but it hasn't been brought to them yet because it's after the indictment. So it needs to have probable cause hearing, which is a 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase. And that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to a probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case. And in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase.
So there are different rules, obviously, for death penalty cases, which is a capital case, and non-capital cases. It's easy to get confused in those. Later on in the hearing, she's going to cite, no, I'm actually talking about non-capital cases. That's what this rule is. She and the judge kind of go back and forth. You can also hear the judge kind of correct himself a couple times throughout this hearing, like, oh, the grand jury actually did do this, or, oh, this is what that rule says. But we're also going to hear him read some of the aggravating factors. And it's like, what Lori Vallow really needs to prove here in this motion is there's not sufficient evidence for these aggravating factors to even go to the jury, which pretty clearly not if she is convicted, which is the standard in how you look at all this. If you're convicted, does it make legal sense? Is it legally appropriate for these aggravating factors to go to the jury? Now we know aggravating factors make a sentence harsher, make a sentence worse, can add time to a sentence. Seems like there's only one sentence in this case. If she's convicted, she's going to get that sentence. So what's the point of the aggravating factors? Is it overkill? I kind of agree with that kind of thought process throughout this hearing that we're going to hear, but we'll also hear whether or not it's legally appropriate for the state to do that.
And then you have a mitigation aggravation phase.
Actually, have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
Guilt phase, aggravated phase, penalty phase. And she's probably working on some other case. She's like, this is so annoying. She doesn't understand basic things about being a lawyer. You know, we're wasting our time here for Lori Vallow to have her moment in the sun.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt.
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
Okay. Hold on one second.
That's what I said. I don't think she was very happy with that. She's like, okay. She's like, I guess we're going to play it like this. And then we get this where she leans over and talks to her. I think that's either her investigator, her advisory counsel, or her paralegal. And I have a comment on that, but just watch this. He's whispering something to her. She's taking notes. The other person sitting next to her, who I think is her advisory counsel, the female. I don't know if this,
You have the allegation of
if this man is her investigator or paralegal or lawyer, but I know the female sitting next to him, I think, is her lawyer or argued in another court hearing on her behalf. I have never seen a pro se litigant get the amount of advice and involvement by standby counsel that I've seen for Lori Vallow. I've tried cases against pro se defendants. We've watched multiple pro se defendants here on YouTube around the country together. Never have I seen this much involvement. You are supposed to waive your right to have lawyers help you with this case, basically. If something comes up and you have a big question, you can go ask them. But she's talking to them nonstop. They're sitting in the courtroom with her. They're prepping things. They're listening in on things. I have to believe they're helping her write motions and do research and explaining to her how to argue some of this stuff. I have never seen this much involvement. It might just be how it is in Arizona. This is the first one we've watched in Arizona together that I've ever seen in Arizona, but kind of wild to me. Like, this almost makes it to where it's like you can have your cake and eat it too, which makes the system more difficult. If you're going to handle it yourself, you shouldn't. But if you want to, it's your right. But this is almost like you get to become the managing partner of a law firm. That's what it feels like. She's now lead counsel with a team trying the case. Is that how it should be? Maybe that's how it should be. America, right? We want the rights. I don't feel like that's how it should be personally. But what do you guys think?
Okay.
It was on my desk.
I would just like it to be on the record clear that the rule 13.5 that I'm talking about is about non-capital cases.
So they lean over. They help her. They tell her where it is. No, the judge is actually wrong, which she would never know on her own, right? Clearly, she did not know that on her own. And you hear a little sigh by the judge, and you hear him open up his book, probably. He's turning to that rule.
I know in capital cases, they call it a conus hearing, but this is for a non-capital case.
This is how they do it in capital cases, Judge. But this is not a capital case.
Well, it says under 13.5a, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you did a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense.
As you hear these aggravators, you're like, "Whoa, seems like some of them might apply to Lori Vallow."
This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior
He's trying to get her to make an actual legal argument that he can just deny.
convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty, for example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one.
And again, it's hard sometimes when you're used to doing things a certain way and you're a judge, you're used to dealing with lawyers and explaining things and lawyers understanding things, where it's like, this seems so obvious and commonsensical, but I will still explain it to you.
The offense involved,
As he should, by the way.
the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5,
Yeah, only if.
right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
All right. 13.5b talks about amending the charge or the indictment.
Mhm.
Okay. Your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why?
It does feel a little bit like, and this is common in pro se cases, like two lawyers arguing, because don't forget, judges, they're all lawyers. Judge Beresky's like, let me explain to you why I'm wrong, when he's also the decision maker, or why you're wrong, sorry, and he's also the decision maker. He's like, nah, that's not really how it works. That's not how it's done. That's not why you do this. It's not how you do that. It's not what this rule means. That's not what charge means. This is not a capital case. And Lori Vallow's like, well, but still. And again, she has a right to make her argument, put it on the record. And I think some of her arguments have actually been okay. Some of them have been totally horrible and off the wall and nowhere near legally sufficient. But she has a right to make her arguments, and you can tell the frustration is building a bit between them.
Isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence. And if it's already a dangerous crime, then there's no reason to have an aggravator phase.
So she's not wrong about that. This aggravator is not actually going to make her sentence worse. So what's the point? She's already serving multiple life sentences in 2 different states now. And if she gets convicted here, like this charge feels like a pile on. What's the point of the aggravator? Now, I get the charge, I get the trial. There's another victim. He deserves justice as well. Lori Vallow deserves full justice on her head. But is the state just piling on? Let me know. What's the point of having these aggravators, right? And we're going to hear what the judge says the point is, but it is kind of like.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge, is what you're telling me, right? Because it's conspiracy to commit first-degree murder. That's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with,
The judge is like, yeah, I guess you're right. There's only one sentence. What's the point? Why are we doing this?
the jury is not.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to.
I wonder how many times she's had to do that. She's like, I've got to come back and do this again. So just in case the law changes, that's her answer. Just in case the law changes, we want them to find these aggravators. I feel like a criminal defense attorney can make a pretty good argument against that. If I don't really know the whole procedural history, I don't know if there were timing issues. I don't know if they did ask the grand jury the right question or did not. Lori's not going to be able to appropriately articulate that. But that answer from the state tells me this is not legally necessary, even though it might be legally appropriate, right? Those can be different. It can be legally appropriate to do something, but it's definitely not necessary. This does not feel necessary in this case, right? Especially because this is not the only sentence Lori Vallow is going to be serving. Now, she could win on appeal those other sentences, and this could end up being the only one, and I get it, but she's still going away for life. So what's the point here, really? And I do think that this could be different under different circumstances with maybe a different judge, maybe a different defendant, maybe with a criminal defense attorney, but I think we all know kind of how this is going to go for Lori Vallow.
Since we're already going to have an aggravation phase for the dangerous
Or do we?
allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
how is it not already found to be dangerous? You just said that if they find me guilty, then it will be.
She's missing it. She missed the argument she could have had to potentially win this, that this is not necessary. This is piling on in the interest of justice. I have a speedy trial right. I don't have time to prepare for this. This is different. Make it seem like a big deal to the judge and maybe an appellate issue on the other end. And it's not necessary. You can split the baby and let the state do everything they want and not give them this. But she, of course, misses the boat.
Dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve? In this case, with this charge, with one statute, you can't give me less time, you can't give me more time, you can't do anything else except for there's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes
He's like, I don't know. She wants to do it for that reason. I guess she can.
of sentencing, and they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know what would be presented at a sentencing phase from your side or from the state side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators. Being a dangerous offense and these
Can
specific
I finish
aggravators
what I
are
said?
different,
What I was saying?
right?
I didn't interrupt you. Can I finish?
So both of them are getting frustrated, both kind of for the same reason, because Lori Vallow doesn't know how to properly articulate an argument or follow where the judge is going, the prosecutor's going, where she should go. That's not going to stop her from snapping at the judge and cutting him off. And he's like, listen, as annoying as you've been, he didn't say that, I've let you finish. So why don't you let me finish? Let's hear that again.
Probable cause for these aggravators that were not taken to the grand jury initially?
All right,
By the way, she keeps making the same wrong argument, which is frustrating to him.
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators. Being a dangerous offense and these specific
Can I finish
aggravators
what I
are
said?
different,
What I was saying? I
right?
didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So
I don't know. I guess they said they're going to, but they don't actually do it. So it doesn't mean they attempted to do it, I guess, right? Because I feel like that could be, if you attempt to do that, it's dangerous. And she's right, but the way the sentencing guidelines are written, it's like, was this dangerous, right? And we've seen juries do some weird things on this, where maybe they feel bad or they feel like it's splitting the baby, where they don't find that on certain crimes. But he's right. 99% of the time, they are going to find that.
A dangerous instrument or deadly weapon was used.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state.
It's actually better for Lori Vallow to not have it happen in the guilt phase. It's better for the criminal defendants for it not to happen in the guilt phase, because sometimes it almost assumes that you're guilty if you have these aggravating factors.
Has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in. And what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts.
you're not entitled to one.
Okay,
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
this is not an amendment of the indictment?
It's not. There's a difference
It's an
between,
extension of the indictment. It's not in the indictment.
it's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing
I would actually argue it's broader than that, than what the judge is saying. Personally, I disagree with him there, but regardless.
as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
But that's
aggravators,
exactly my point. How does, after the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to an probable cause hearing.
Okay, then I don't,
That's definitely not a reason for that ruling, but he's annoyed at her now. He's frustrated at her. It's very clear, not showing bias, not being unfair, not being prejudicial towards her, but he's definitely annoyed with her. And I can't blame him, frankly.
want to have an aggravation phase either.
Well, you can
How
not,
are you entitled to that? And I'm not entitled.
Like, if a lawyer was yelling at a judge like this, I think he might be sent out of the courtroom. So she's actually getting more grace and patience than a criminal defense lawyer would get in the same circumstance if they were doing the same thing, which they shouldn't.
probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can
How
not,
are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
well, if you don't want to attend, you don't have to attend.
He's like, you can waive your right to be there. You don't have to be there if you don't want to, or having it, you don't have to be there. Just like, again, not great, but like, that's how you end the conversation. She's like, I don't want to have this. It's like, well, that's fine. I'm sure you don't want to go to prison for the rest of your life, but it's going to happen. Because you don't want it, doesn't mean it's not going to happen.
What else?
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your,
And again, this comes back to the level of advice she is getting from advisory council is next level to me. And again, she's like, why can't we have more than 5 headsets? And it's not just her 5 headsets, it's total 5 headsets. She gets 2. And, for sidebars and things like that. And just her demeanor it's getting under my skin a little bit. The way that she's talking to him, the way that she's demanding things, the way that I want it now, Daddy. I want more headsets now. That's what it feels like. It's like, it's not how it works, Lori.
advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and there's
they
no
can't
more
do-
available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between.
That's more than fair when she's representing herself to still have another headset for any one person she wants to ask.
The people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing because you are acting as your own attorney. You're expected to proceed as your own attorney.
I don't know of any right to have advisory council listen in on everything and including sidebars. It's like you're representing yourself. If you need advice, if you need to ask them a question, go ask them a question, but they're not your co-counsel. They're not your co-counsel. That's what this feels like, that they're her co-counsel.
They don't have an affirmative
Every judge handles this differently. How do you think Sarah Boone's judge would have dealt with this?
duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you. Okay. But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Okay. Yeah, I did. In case you decided not to
She's like, it's your fault. You appointed them to me. I didn't even ask for them. It's like, well, you don't have to use them. Nobody's forcing you to ask them a single question. Don't ask them a question if you don't want to. You're choosing to ask them questions. You're choosing to want to give them headsets, not me. I'm not choosing to give them headsets. You are. But you don't want to get into that battle with Lori Vallow. So it's smart that he didn't, but just, it's frustrating. It's really frustrating.
represent yourself so they could step in at trial.
Okay. Well, then is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time.
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question, issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that.
And he's still trying to help her out. And that's how you can tell. Even though he's getting snippy with her sometimes, frustrated with her, she's being insufferable. These are the moments you can tell he's not unbiased. He's like, okay, fine. That's reasonable enough. If it's simple, no. But if it's more complex, we'll have everybody up at the bench. So you can have advisory council up there too. That's more than fair. It's more grace than she deserves. Well, then probably most people would say she deserves Everyone deserves grace to me. Nobody's past being redeemed, even Lori Vallow, which is, she's as far down the line as you can get, but hopefully she comes around one day.
But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay. I have one more issue.
Go ahead.
Okay.
Even the way she says, okay, it's like, okay. So then I have to choose one person. Okay. It's like, again, we're talking about, do you think she's trying to get under this judge's skin purposely to prove she was right, to prove he's biased, to try and file another motion to get him recused? Or is this just how she acts? It seems like it's ticked up a notch in this hearing. I could be wrong. I could be just sensitive to the fact that we just watched the hearing where she was trying to get him recused for some of the comments he made and the way he's acted and treated her.
Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Accused by you of opening the door. I would call it warned. You've been warned, Lori, that you may be opening the door here. I'm not accusing you of it. I'm trying to warn. That's what he did the last trial, right? That's what he did in the Charles Vallow trial, is warned her. He didn't accuse her. He warned her.
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yeah, sure.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or prior proceeding, that maybe we should take a break.
Okay.
All right. Anything else?
That was it.
All right. We'll see everyone.
She said, if all parties. That also means that we can bring in.
All right. So that was it. And even that, he's like, we'll make sure that they don't talk about Idaho or any prior proceedings. So they're picking the jury, I think, right now in the Lori Vallow case. Nate Eaton, I followed his Twitter. He said it's going slower than the Charles Vallow trial. So I don't know if that trial has piqued more interest or why more people feel like they can't sit on this jury or why it's more difficult to pick a jury for this trial. That's not abnormal when you've already had a trial in that state about the similar crimes with the same defendant. That was reported on, right? Heard from jurors, everything. So I think they need to be careful. Pick a fair and unbiased jury. Give Lori Vallow her fair shake. But what I want to know from you, do you think this trial is going to be more snippy, more snappy, more snarky than the first trial with this judge, with Lori Vallow? My guess would be yes, but I want to know what you guys think. And if you're still following this trial in this case, I know Karen Reed's going on, Diddy's going on, lots of other stuff going on. If you are, please let me know in the comments and let me know by liking the video if you want me to keep following up as much as I can with the case where Brandon Boudreaux is the victim for Lori Vallow's second trial in Arizona. All right, that's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.